As far as Fed trends go, the criminal charge of conspiracy against rights is so hot right now. It's a post-Civil War federal law designed to stop the KKK from physically blocking black people from voting. It's uncommonly prosecuted historically, but it's having something of a creative resurgence as the feds give it broad new application. They just convicted Douglas Mackey on this charge earlier this year. On Twitter, he was formerly known as Ricky Vaughn for his joke posts in 2016 urging Hillary voters to vote by text, something, of course, you can't do yet, at least. Since the meme was a few years too early to be true, he will sit in prison for conspiring against your right to vote. Just at the end of August, the DOJ secured convictions for 5 pro-life protesters who conducted a sit-in protest at a late-term abortion facility in D.C. And it's not just that they trespassed, it's that they conspired to violate your rights. So they're facing a decade plus in federal prison too. And of course, this law is a major component of special counsel Jack Smith's January 6th indictment against Trump too. Same idea. It's not just that Trump sought legal pathways to challenge what he viewed as election irregularities. No. He conspired to violate your constitutional right to have your vote counted. Beyond the resurgence and the ever-broadening definition of what is a constitutional right to be violated by the similarly broadening definition of what is a conspiracy, there is another important trend here, or maybe less of a trend and more of a permanent truth at this point. It does not count when they do it. Actual conspiracies to violate your actual constitutional rights by those actually in political power right now receive no such aggressive DOJ prosecution. And no, I'm not just talking about that lady down southwest who thinks she can just cancel the Second Amendment on her whim, openly stating, I'm not just conspiring to violate your rights, I'm just doing it, and betting you won't do a damn thing about it. I'm talking about the highest levels of the federal government, senior staff at the White House and at the alphabet agencies, not just accused of conspiring to violate your rights, but now court adjudicated, at least preliminarily, to have done it twice, and not just with some made-up or stretched pseudo-constitutional right, but with your first one, the first individual right protected by the Bill of Rights, your right to speak freely. The conclusion that the Biden administration has been violating the First Amendment comes as no surprise to anybody who's been paying any attention at all. Of course, they told us they were, early and often. It was one of Jen Psaki's first statements from the podium as press secretary in 2021. She said openly, "We at the White House want Twitter to reduce what we view as hate speech." Never mind that term has no legal definition to justify their intrusion in the matter at all.
Does President Biden support the continuing ban of President Trump on their sites?
I think that's a decision made by Twitter. We've certainly spoken to, and he's spoken to, the need for social media platforms to continue to take steps to reduce hate speech.
Of course, that was explained away as just a suggestion, not active meddling, until 6 months later when Jen Psaki again said, yes, we are flagging material for Facebook to remove.
We've increased disinformation research and tracking within the Surgeon General's office. We're flagging problematic posts for Facebook that spread disinformation.
All you really had to do was listen to them tell you that they're doing it to understand that they are. So enter a lawsuit in federal court to put a stop to it. In May of 2022, the Missouri Attorney General, joined by the Louisiana AG and other parties who had their posts removed or their accounts punished, they say at the direction of the White House, filed the lawsuit Missouri v. Biden, bringing a lot more than just Jen Psaki's public statements as evidence. According to facts presented in the case, the White House's oversight of content moderation on social media was deep and wide. Regular White House communication with Twitter, Facebook, YouTube, Google, and others began in early 2021, as in right when Biden took office, the White House assumed a big role in speech oversight that it hadn't previously. White House officials gave instructions to social media platforms for specific posts to remove and to do it immediately as soon as possible. The White House monitored the platform's moderation activities and received frequent reporting on progress. The White House lobbied for policy changes to eliminate content they didn't like and even had their own perspectives amplified. Hey, delete that guy's vaccine skepticism and instead boost our vaccine promotion. And the social media companies largely caved. Even that probably implies too much resistance. In many ways, they sounded eager to comply. Platforms gave the White House dedicated staff contacts for content moderation, and in at least one case, even created a dedicated portal to facilitate the communication efficiently. A direct priority line for the White House to say, hey, here's a post to delete. Get on that. So in effect, the White House was pulling the strings on the public conversation, controlling, at least in these arenas, what perspectives win and what perspectives lose, or what perspectives are even allowed to participate in the debate at all. And even if the White House isn't pushing that delete button themselves, that sort of First Amendment workaround of government getting some private sector puppet to do it for them is still a constitutional violation, not because I say so, but because the courts do. This sort of thing has been adjudicated before. Of course, government is entitled to engage in meetings, government is entitled to voice its own perspectives, but the First Amendment is violated when the government coerces or substantially encourages third parties to censor certain viewpoints on its behalf. And the district court judge who first heard the case over the summer agreed that the White House did, or at least that the evidence suggests that they did. And not just that the White House did this generally, but that they censored on an unprecedented scale. Judge Terry Doty wrote that these allegations involve the most massive attack against free speech in United States history. And so to stop that abuse while this case proceeds, the judge issued a broad injunction blocking the named federal officials and agencies from meeting with or speaking with social media companies at all, save just a few exceptions for issues like crime or international threats. Among other consequences, this move caused the State Department to temporarily suspend their regular monthly meetings with Facebook. Regular meetings most of us learned only then were even happening at all. Meetings that raised the question, what exactly was being discussed here? Was it just the government offering its own opinions in a respectful, hands-off way, or was it, as much of the evidence suggests, the government giving Zuck and company a censorship checklist and direction to get at it immediately? And of course, with that order, Biden, now caught in the act of actually conspiring against your actual rights, couldn't just say, whoa, sorry about that. That's not what we meant to do. We won't be doing that anymore. No, he had to appeal the order so that his actual conspiracy can continue. So he took the injunction to the appeals court, which released its own evaluation Friday. And in case you think that prior judge was just some anti-Biden ideologue, we now have the appeals court's affirmation. Yeah, the White House violated the First Amendment. And yeah, they really got to stop it. A 3-judge panel of the Fifth Circuit Court of Appeals ruled the district court judge was correct that the White House and its buddy alphabet agencies coerced or significantly encouraged censorship on social media to the degree that those count as state actions, just the same as if the government itself had hit the delete button. In doing that, the White House and other federal agencies violated the First Amendment. And the appeals court judges also agreed that this isn't just some small or routine issue. The decision reads, quote, prior case law has rarely been faced with a coordinated campaign of this magnitude, orchestrated by federal officials that jeopardized a fundamental aspect of American life, a conspiracy to violate rights in more plain terms, and yet no DOJ eagerness to start prosecuting these people, but I'm sure our trusty, faithful, rule of law, by the book, not at all politically partisan Attorney General Merrick Garland is prepping that case for the grand jury as we speak. What little news coverage there is of this development tends to emphasize the opposite, actually, that somehow the court is siding with Biden because the appeals court scaled back the district court's order squelching the Biden administration's contact with social media platforms. And that is true. The appeals court did conclude that the district court judge's order banning White House and other officials from contact with social media companies generally was overbroad. So the appeals court narrowed it to say that White House and other federal officials can't threaten, pressure, or coerce social media companies to remove content containing protected free speech. They can still meet and discuss for other reasons, though. But what is actually the headline level information there? It's that they were doing that in the first place. It's that the White House was coercing social media companies to remove protected speech. That is a scandal of foundational importance to this country. And the same press that's supposed to defend that principle as the one that secures their very existence has hardly a shrug for it. The appeals court's ruling gives Biden 10 days before this new order takes effect, allowing time for the White House to appeal to the Supreme Court if they wish. At first, I hesitated to think that he would, because a likely Supreme Court finding that he's been violating the First Amendment for years would be heavily damaging to his re-election campaign claims of defending the Constitution otherwise, but then again, he hasn't hesitated to do it in the past. Of course, he appealed his plainly unconstitutional student debt bailout to the Supreme Court, knowing the smackdown that was coming and doing it anyway, so given the past performance, it shouldn't be surprising to see the same move again. But why is he doing it is the simple and primary question to ask, though. Is he doing it to stop crime? No. Per the court's order, he's allowed to talk to social media companies about that. Is he doing it to stop foreign meddling? No. He's allowed to talk to them about that. Is he doing it to stop national security threats? No. He's allowed to talk to them about that, too. The only thing he's not allowed to do under this court order is tell Twitter or Facebook or the rest of them to take down your post because he disagrees with it. That simple, baseline First Amendment compliant rule he disputes and quite possibly will appeal to the Supreme Court. And anybody who actually had any First Amendment loyalty whatsoever would have no problem with this court order. That person would accept it and say, that's fine. I have no intention of policing viewpoint anyway. And even if some of that sense finally does emerge and he doesn't appeal this ruling, well, it's too late regardless, because this isn't a case about what Biden might do under these rules. It's a case about what he's already done to make the rules necessary in the first place. He trashed your constitutional right to speak freely while grinning and insisting the opposite, that he is actually the lone guardian protecting you from the constitutional collapse that his opposition will bring. It's a conspiracy to create a conspiracy. Don't look at me. Focus on those bad guys over there. But it's not just a distraction. It's protected by force. If you do look at me instead of those bad guys, well, then I'll just delete your post telling everybody what you saw anyhow. If he doesn't respect your first constitutional right, he doesn't respect the rest of them either. Historically, we've had prescribed solutions for such people. Consult the language of the Declaration of Independence for the references. I would explain them, but then of course, I'll be an agenda item at next week's regular Facebook Fed meeting. Then again, perhaps I am being a little unfair. After all, it's not like Biden has ever demonstrated a solid understanding of these concepts anyway.
We hold these truths to be self-evident. All men and women created by you know the thing.
Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below and especially over on Minds, that is at ML Christiansen. You're always welcome to coming out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.